Can you see the PowerPoint?
Yes, madam.
Yes. Yes.
We can.
Let me just start it. Oh, great. Excellent. Just wait a second until I close the door and we'll be starting. Hi. So, good evening, everyone, and welcome to the course International and EU Law and Gender Equality. Let me briefly just introduce myself. Although some of you, or maybe all of you, attended the opening ceremony, so we already actually met. My name is Bojana Čučković. I am associate professor here at the Faculty of Law at the Department of International Law and International Relations, and I teach public international law, international human rights law, some other subjects dealing with specific international law disciplines such as international asylum law or migration law, refugee law, environmental law, etc. So these will more or less also be the topics that we will be covering within this master. I would also like to know something more about you, but before that, let's just go through some other issues relating to this course. So this is one of the, if I'm not mistaken, mandatory courses that you will be attending this semester. And I teach this course together with Professor Ivana Krstic, who is the head of the Law and Gender Master Program, and who also you all had an opportunity to meet. So the two of us, since we are professors of international law and international human rights law, will be covering various issues concerning international law. Just a second, Professor Vujadinovic is here. But for the other course. Teaching this course, and these are Professor Maja Lukić-Radović and Assistant Professor Marija Vlajković. The two of them will be working with you in the second half of this course because both of them specialize in EU law, European Union law. So the topics related to EU law and gender equality will be covered by them. How we will be working? Well, more or less you got an idea from my introductory email. So did you all get that email? I hope so. There is no particular reader for this course, but we will be using Moodle. Are you all already using Moodle? No. I'm looking here in the room. I also have one student here in the room. That's why I'm not looking at the screen all the time. So it's a bit challenging, but we'll manage. Sorry, your name, please. Dushanka.
We don't have the access to e-student.
To e-student.
Yeah, we are waiting for, I don't know,
something to happen.
Something to happen, and then you will see the username.
Okay.
To this course.
Okay. But anyway, I mean, I sent you the materials by email, and I will always send you the materials before the course, so that you can read them. Sometimes there will be more of them, sometimes less. You will not always have enough time to go thoroughly through them, and this is not the idea. So the idea is to just introduce you into the topic, and then, as you will see, we will always use some kind of PowerPoint presentation, which will also be very, very thorough to help you prepare for the exam. So after the class today, I will send you the PowerPoint. You will have it for your personal use. And it will also be available on the Moodle. So all the materials that we send you and all the PowerPoints that we use during classes will be available during on the Moodle platform as well, once you are able to access the platform. So what will be the topics that we'll be covering? We'll start today with an introduction, with a general overview of international law and the links with the issue of gender equality. I will go into more details a bit later. We will also cover actually, you will cover on Saturday with Professor Kristic the international gender equality and international diplomacy and judiciary. This will be more interesting than what we are going to speak about this evening. I have this boring part of the talk, and Professor Kristic has this interesting part of the topic. So prepare on Saturday. It will be very, very interesting. And then afterwards, during the next week and a half or two, we will be covering gender aspects of different areas of international law. For example, next Wednesday, I will be again working with you, and we will be dealing with international environmental law and gender aspects. So how the pollution and the degradation of our environment impacts women and men differently, and what are international instruments and mechanisms available for that problem. Later on, you will also deal with international criminal law and gender equality, international humanitarian law and gender equality. Not all areas, special areas of international law are equally gender sensitive, but we will go through some of them, those that are most gender sensitive. During the second half of the course, you will be dealing with EU law topics, but I won't go through that. This is not my area of expertise, so this will be covered by Professors Lukic and Lajkovic. Before I go further with some other technical issues, I would like to meet you. So I have here a list of your names and your academic background. So Ksenia, is Ksenia with us? I cannot now see you all.
Yes, I'm here.
Ksenia, you're here. Great. Ksenia, so you are our student from the University of Belgrade Faculty of Law.
Yes, I graduated. I'm actually currently on my way to the faculty to meet you in person. However, the traffic in Belgrade is crazy.
Yeah, you're not here alone.
I'm trying to reach the faculty. I'm working in New Belgrade. Belgrade, and the traffic is crazy. So that's why I'm a bit late. I'm sorry, but I will make an introduction nevertheless. I graduated from the University of Law faculty, our faculty, 6 years ago.
6 years
and
ago,
after 6 years ago, I believe, yes. And to that, I went on my career path first through attorney's law office, where I gathered some, practical knowledge. After that, the construction firms, and now I'm representing the bank. So this masterclass is something very personally interesting to me and my personal passion. It's not related to my work expertise at all, but through my during my working years, I encountered a lot of cases and issues that are related to this topic, and that's why I'm very interested to learn more and to help me deal with all of this in work and maybe educate others.
Great, excellent. I'm happy to hear that.
Yes.
It's always, it's best. It's always better to study what you're interested in than what you have to.
I decided to follow my heart instead of the rationale.
Great, I'm happy to hear that, and we're eager to meet you here also.
I am there in few minutes.
Okay, great.
Thank you.
Welcome. Now I have Una Danilovic. Una, are you there?
Yeah.
Hello, Una. How are you?
Good, and I'm sorry for not being there in person. I was there yesterday, but today also because of the traffic and the flu that's going around my house, and we're passing on to each other every day. So I decided it's better to stay online.
Okay, great. Una, if I am not mistaken, you haven't graduated from our faculty, but University Union Faculty of Law.
Yes.
Great. Okay, so welcome to the Faculty of Law, University of Belgrade.
Thank you.
It's great to have you. Why law and gender?
Well, after I graduated from University of Union, I started working at the Lawyers Committee for Human Rights. And also at the faculty, I worked on obstetric violence, but also domestic violence and other forms of gender-based violence, and kind of continued that work through free legal aid at UCOM, but also in forms of advocacy, international and national level. So I have a little bit experience in gender-based topics in practice, but I would also like to have a theoretical knowledge and a point of view.
Great. Then you are at the right place for that theoretical framework. Great, Una, welcome. Dušanka, you are here. So you also are a student.
No.
It says Faculty of Law, then this is a mistake.
No, it's Faculty of Law because on the application note, or in the English version, it's Faculty of Law, but for other related faculty, I'm Faculty of Political Science.
Political Sciences, okay.
For international relations.
So how come you're interested in gender issues?
Well, I work as advocacy program coordinator at LAPIS, that's Lesbian Human Rights Organization. I worked there for 2 years, in 2023. I started working there. And this topic is really something that is mine, in the heart. And with the working with others, we had something called, strategic litigation for passing the law on unions, and that's something that really got me interested in law. But was before, during the bachelor studies, every year we had 2 or 1 topic in law, and it was really interesting for me. And I went back when I decided what I'm going to be studying for the bachelor. I was being for either law or political science, so this is something like
a combination. Your face is so familiar to me. I feel that we already met.
Women months ago.
Huh.
Maybe you were there.
Yeah. That's it. That's it. It must be that.
So
Yeah.
maybe that.
Yeah, because when I saw you at the opening ceremony, I thought that you were our student. I don't know you from the back.
Just the invitation,
Yeah.
they didn't give me the opportunity to say that I'm from political science. So yeah.
Great. Dushanka. Okay. Alexander Lisulov.
That would be me.
That
Hello.
would be you. Hello, Alexander. How are you? Yeah.
I'm doing well. We've met in the opening ceremony.
Yeah, great.
I'm also a student at the Belgrade Faculty of Law. I graduated last year. And this is just a continuation of my education. I intended to join the Law Jam Master last year, but wasn't able to graduate in time. So this year it is.
Great.
I'm
Have you?
pretty interested in the subject matter of this master. It's something I've looked into as a matter of my personal interest. I've always followed politics, the way they affect culture.
She is on a business trip, so she's the only one, I suppose, not present this evening. But she said that she will be joining us for the rest of the classes. She will come back. And if I'm not mistaken, two colleagues from abroad, two students from abroad, Sharmarke Abdisam Adiri, are you there? No. What about Saiful?
Yeah, I am here, madam.
Great.
This is Saiful Islam Muhammad from Bangladesh. I completed my graduation from Finance and Banking Department, University of Rajshahi, Bangladesh. And now enrolled with you, learn law and gender issues from you. That's all.
Okay. And will you be coming to Belgrade?
Coming to Belgrade maybe in the January.
In January.
Yeah.
Okay, great. We'll be here to meet you and looking forward to having you here. Meanwhile, we'll be seeing each other online.
Yeah. Thank you.
Great. Fine. I have now one technical information for you. At the beginning of the course, before we go into the subject matter of the course, we have some technical issues. I was just told today by our head of the master program that I will again be the one examining you for this course. So it is up to us to decide on how the exam will look like. We do not have to decide it tonight. You can maybe think about it. What we did last year with our students in this course was that I gave them the opportunity to choose a topic that is, of course, related to the subject matter of the course. So to write an essay, let's say 10 to 12 pages long essay dealing with any of the issues that we discussed during the course, but researched from the perspective of international and EU law. So that is one option. If you prefer research and learning something more in this area concerning the topic that is of interest to you, then this is fine. Another option would be, if you prefer the classical way of being examined, that we have an oral exam, which would actually be, which would rely on the PowerPoints and the materials, but mostly PowerPoints that we will be using during the course. So it really depends on what we decide. So think about it. Think about it. Last year, all the students, we had an excellent group and we really worked very, very successfully throughout this course. And they all took very different and very interesting topics. Some were really under-researched, and their essays were very useful. So that might be an option. So then I would assess the essay, your work. Of course, during the course, it goes without saying that what will also be assessed is your participation throughout the course. I will not be always here, of course, but I will communicate it with other professors regarding your participation in their classes, the homework that you would be doing, if they give you some homework. So we will be in contact regarding these pre-examination obligations. But for the final exam, you can maybe decide whether you prefer a written or an oral exam. How does this sound to you? Fine? Alexander,
Yes,
I can only
that's fine.
see you. That's why I'm asking you. I can see your eyes and that you're listening. So I'll have something. We'll see each other next Wednesday. We can maybe discuss that again on that occasion. And also, I will be always available by email, so you can write to me anytime. Of course, if you decide to write an essay on a particular topic, this means that you would have to communicate it with me. So you come to me with a couple suggestions, and then we decide which is the topic which is the most appropriate, how to formulate the topic, how to structure it. So this will be, in a way, mentored work from my side. I will be a support to you along the way. And this will also, I'm sure, be a good preparation for the master thesis. Because this will be, in a way, a small master thesis before the huge final thesis that you will have to write. Not necessarily the same topic, but still, some of the students that did this essay within this course decided later on to broaden it and then write their master thesis about it for the end of the master program. So think about it. I'm open for any suggestions additional that you have, but it appears to me that this would be a good balance, your presence, your regular attendance, your participation in classes, homework, assignments, whatever professors give you, and then either the oral exam, classical one with 2 exam questions relating to any of the topics that we discussed during courses, or to write an essay 10 to 15 pages long on the topic which is dear to your heart. So
I just have a question, if it's okay.
Yeah, of course.
Is it a group decision or it's an individual decision?
It doesn't have to be a group decision. It doesn't have to be. You can.
So as we prefer.
Yeah. But
Okay.
I would like to know that. I mean, your decision towards the end of the course. Okay, so that I can have an overview of how to organize the exam. You will be able to take the exam already in January examination term, which will be actually in February this year. So maybe start thinking about it and try to finish as much as you can before February. We can finish this even before the examination period starts. Okay. Good. This is more or less what I wanted to go with you through before we go to the subject matter of our topic today. If there are no further questions, let's start with it. What I would also like you to know, you can interrupt me anytime. So I will. This will be, as I said, an introductory and an overview of different instruments, mechanisms of international law that is relevant for gender equality. So we will revise certain things. Dushanka, you have public international law at the Faculty of Political Sciences? No. Okay. The rest of you, did you have public international law during your bachelor studies?
Yes.
Yes, Una had. Okay. All our students had, I know that, but Saiful, did you have public international law?
Yes, ma'am. I also completed Bachelor of Law from 2 years Bachelor of Law from Islamic University, Kushtia, Bangladesh. I know public law.
Okay.
No problem.
Okay. But I will revise some very important issues because public international law is a very specific area of law. Yeah. So what we will be doing this evening is the following. So I might not be able to see your hand if you raise a hand. So please just unmute yourself and start talking if you have any question or comment, okay?
Okay.
Fine. So two different aspects. So what we will discuss this evening is to what extent international law is gender sensitive. We'll go through its instruments, through its mechanisms, and see whether gender sensitive provisions are contained in different international sources of law. But on the other hand, always have in mind the practical aspects of the topic. So how can we use it to advance gender equality? How can we use these instruments or mechanisms that international law disposes of to fight gender inequality? So these two different aspects to think about the topic are very, very important. I will start with a very recent example. I don't know whether you are familiar with this and what this suggests. You can see two pictures. One is picture that obviously relates to the situation with women status and women rights in Afghanistan. You can see how the situation was back in the 1970s, the University of Kabul, when women were able to go to the university and attend university studies, as opposed to the situation today, which is deteriorating. I'm sure that you are aware that the Taliban introduced certain legislation, even forbidding women's voices to be heard in the streets. On the other part of the slide, I have the photo of this building. You can see what that institution is. So this is the International Court of Justice. This is the principal judicial body of the United Nations that we will be talking about this evening very, very much. So the World Court, the most important court when it comes to public international law. Does any one of you know what do these two things have in common?
Well, I mean, because what countries are doing, the laws that are pursuing and passing are automatically going against UN values, and therefore can be obtained in the court. And I mean, like that's something.
Yeah, but if I tell you that it is very, very difficult to bring a case before the International Court of Justice, only states can do that. So this is a court that deals with cases between states, with disputes between states. Individuals are not qualified as parties before the International Court of Justice. Secondly, which is even more problematic, a state, the court needs to have a basis for its jurisdiction, meaning that the states involved in the dispute have to consent to its jurisdiction. Meaning that any state cannot just go before the court and sue this or that state. That state also needs to consent to it in one way or another. One way of doing it is explicitly in a particular dispute that has arisen among them. But there is another option. Some of the international conventions contain the clause, so-called compromissory clause, enabling the court to have jurisdiction relating to disputes that arise from the application of that particular international convention. So this is what happened in this case. Are you familiar with the CEDAW Convention? Yeah. Dania. Good evening. Welcome, Dania. Hi. So I mentioned the CEDAW Convention. The CEDAW Convention, the Convention on the Elimination of All Forms of Discrimination Against Women, it contains within its provisions the so-called compromissory clause. It allows contracting parties to go before the International Court of Justice in disputes relating to the application or interpretation of that particular international convention. Afghanistan is a party to CEDAW. Other states are also parties to CEDAW. So what we had last September is the announcement of 4 states, Australia, Canada, Germany, and the Netherlands. So these 4 states announced that they will be initiating some proceedings before the International Court of Justice against Afghanistan because of the obvious violation of numerous provisions contained in the CEDAW Convention. I gave this at the start, very start, so that you can see that there are actually various international mechanisms, instruments that can be used to fight gender inequality. We'll see whether this will happen. There are some preconditions that have to be met before going before the International Court of Justice. So states need to try at least to use some other peaceful diplomatic means at their disposal to resolve the case before going to the court. So this is a long road ahead of these 4 states, but it means something. It means that a part of international community, and this initiative, it was supported by 22 other states. So it means that the international community recognizes the problem in one particular state, the massive violation of women's rights in that particular state, and that they are willing to do something. It's not their concern, but still they want to spend money, to spend some time, pay very expensive lawyers that will be representing them in the proceedings before the International Court of Justice in order to fight gender inequality. I'm not saying that this is a perfect solution and that it will actually change something, but still you can see that there are various instruments, and I will go through other during the presentation, that can be used even at the level of international law and international judiciary to fight gender equality. But before that, let's revise something, or actually learn something for those who are not familiar with public international law. So what I wanted to first go through is the specifics of public international law, because this is a very, very specific area of law, quite different from national law, quite different from what we are dealing with at the level of domestic law. What is specific is its subjects. So subjects of international law are states and international organizations. I have here a question mark. Are there any other subjects of international law besides states and international organizations? Is an individual a subject of international law? Individuals, are they subjects of international law?
I don't know, sorry, how to explain it, but the conflicted zones and how to say revolution groups, rebel groups.
Rebellion groups, okay. They have some elements of international legal personality. That's right. Individuals, if you talk to scholars who deal with international human rights law, they will say, yeah. individuals do have international legal personality. They can go before some international courts, not all, but some of them. They can be held responsible at the level of international law. You have international criminal tribunals that deal with international criminal responsibility. But if you talk to someone who deals with public international law, general international law, they will say no, at least not yet, because what is the one very important characteristic that feature of legal personality at the level of international law that individuals have? This is the possibility to create rules of international law. And this is another specific of international law. Who creates rules of national law? Parliament. That's right. So it's not the very subject of national law. Not you, not me.
Well, yeah, but look, I mean, that is the indirect way.
Indirectly, yes.
Yeah.
But these are state bodies. Yeah.
That represent citizens.
Legislative organ, of course, but not citizens directly. Who have the legal personality at the level of domestic law? On the other hand, and this is the very specific feature of international law, subjects of international law are the ones who create rules of international law. Because, and this is going to be my next slide, you can recognize this consensualism as a specific characteristic of international law in both the process of creating rules of international law, because all rules of international law, they are created by the subjects of international law themselves, by states, by international organizations. And this is also recognizable in the context of international dispute settlement. What I mentioned earlier regarding the International Court of Justice, is the jurisdiction of the International Court of Justice mandatory for states? No, they need to consent to it for the court to base its jurisdiction and be able to decide the case. So this consensualism is a very specific feature of international law. I mentioned that we can also notice this consensualism when it comes to sources of international law. And this is also something that is very peculiar, quite different from national legal systems. The sources of international law are provided in Article 38 of the Statute of the International Court of Justice. And what you have there are first and foremost international treaties. You can call them conventions, covenants. There are different words for that source. But essentially, what is that? A mutual consent among two or more states that conclude a treaty. So this is a source of law. They decide whether to express their consent to be bound by a treaty or not, but it's up to them. So you can see that, again, their will counts. They decide by which rules of international law they will be obliged and by which treaties they will not be obliged. So this is the situation with international treaties. Second very important source of international law, international customary law. We don't have that in national law. So this is something that is different from national law. But international customary law, how do we, again, recognize this consensualism when it comes to customary international law? Any ideas? Do any of the students that have public international law at the level of bachelor studies, do you remember what are the two elements for an international custom? How is it created?
Through practice.
That's right. Practice, long or sometimes even not that long practice, but consistent practice among a representative majority of states. And then this is not enough. It should be followed by the so-called opinio juris, actually an idea that you are participating in such a practice. Why? Because the state knows that it is obliged by it. So it's not an practice. It doesn't take participation in that practice because it is its interest in that particular situation, but because it is aware that it is bound by such practice. So international customary law is a very important source of international law. And again, you can see consensualism. How? Because state can act in a specific way and be a part of this practice that I think Una mentioned. Una, am I right? You had the answer.
Yes, thank you.
Yeah, great. Or the state can decide not to act in such a way or act contrary to such practice. If the state acts contrary to a specific practice, which at the end becomes a customary rule, it will not be bound by it because it will be the so-called persistent objector. Again, the state is the one who decides whether to participate in such practice or not. Then we have in Article 38 something called general principles of law recognized by civilized nations. I won't go into much detail and explaining there because the Article 38 of the Statute of the International Court of Justice is a very old provision. Have in mind that this is actually a copied provision from the Statute of the Permanent Court of International Justice. So a legal instrument that was created after World War I. Just imagine how international law looked back then and how it looks now. Back then, there were no that many international conventions, no international customary rules. So the court had to have some source to apply in case there is a gap in rules within international law. And this was a solution. So these general principles of law recognized by civilized nations, very simple. These are the rules contained in more or less all national laws of different states. I'm sure you are all aware of the principle of res judicata. Once you have a final decision, you cannot again go into it and question it, re-examine it. So this is an example for that. And these rules that are there in all national legal systems are actually these general principles of law recognized by civilized nations. So these are the rules that actually come from national legal systems. They're not originally international. Something that is very specific for international law, judicial decisions and the teachings of the most highly qualified publicists. So judicial decisions and teachings of different scholars, they are the so-called auxiliary sources of international law. What does it mean? When an international court or an international treaty body or whatever, when they deliver a decision and there is a previous decision of that court or another court, which the court would like to refer to, rely to, it will do that as a support for its argumentation. The same goes for the different instruments, briefs, applications, drafts that states create in the course of different proceedings before international bodies. If you have a case decided by the International Court of Justice, European Court of Human Rights, that goes into your favor, you will rely on it. So this is not a main source of international law, but it is a very important one, auxiliary, because once you have something that was already decided and a standard or argumentation that goes into your direction, what you want to argue, then this is great. The same with the teaching of scholars. If you find, for example, Brownlee or Lauterpacht or Crawford or any of the great names of international law, and you use their statement, their position regarding a particular issue, then this is valid. I mean, you then have a very important argument to use in any proceedings before an international mechanism or body. However, there are some sources of international law that are not contained in Article 38, which have meanwhile become very relevant. These are unilateral acts of states. Let's take as an example, for example, one declaration issued or a statement issued by a particular president of a particular state. Is that the source of international law? It is. If by that statement, that particular person who represents the state takes a certain commitment, then this is also a source of international law because he or she takes commitment towards the rest of the international community. Have in mind that not all unilateral acts are sources of international law. But for example, recognition of new states, we have that in our state. If there is a declaration coming from one particular state saying that they recognize as a new state a particular entity, territorial entity, then this is a source of international law. They take certain commitments through that statement. But many unilateral acts will not be sources of international law because unilateral acts, this is a wide category of acts. Any law, any bylaws, these are unilateral acts of states. They are not all sources of international law, only those through which states take certain commitments towards the rest of the international community or a particular state. Acts of international organizations as well, quite similar to unilateral acts of states, different resolutions of international organizations. We will be discussing them. You have resolutions of the UN General Assembly or resolutions of the UN Security Council. These are also unilateral acts of this particular organization. Are they sources of international law? Well, it depends. It depends. Sometimes they are, sometimes they're not. They will have certain effects towards the states that are parties, that are members of that organization, whereas towards the other states that are not members of that organization, they will not be sources of international law. Soft law, what is that? Huge amount of different sources that are not legally binding. But you will see that, this is why I go into details. You will see that particularly in this area concerning gender equality and advancing gender equality, soft law instruments had a saying, and they were the ones who actually built relevant international standards in this area. Different guidelines issued by international organizations, different, again, resolutions. Resolutions are soft law. Declarations, they are soft law because in themselves they are not legally binding, but they should not be neglected. They do have certain relevance. Is this clear? Okay, now let's go through the topic for today. This was just a bit of a revision to help you understand the rest of the talk. Now that you have some overall idea about international law, its sources, its subjects, its features, how is gender equality actually situated in this discourse? International law, in general, is perceived as universal. So it applies in the international community as a whole. So all states, all international organizations, they participate in the international community, and international law relates to the international community. It tends to be universal. It tends to be applicable to all states in the world. The UN, the widest international organization, it really tends to have within its membership all states of the world. That's fine. But is it actually universal? Well, you have within the UN two very important principles. The principle of equitable geographic representation, because in, for example, UN organs, UN bodies, not all states can participate. They can participate, for example, in the General Assembly. because all delegations of all member states are present there. But you have the Security Council, which only has 15 members. So what is the relevant principle? Equitable geographic representation, having states from different regions of the world so that all regions are there. Another principle upon which international legal system is based is appropriate representation of different legal systems. What? Common law, continental law, Islamic law. So when, for example, judges of the International Court are elected, this is one of the criteria that you have representatives of both common law and continental law countries. And then we come to this final aspect, gender equality, gender parity, and gender balance. And this is what we're going to be discussing today. It is not, and it has not been there from the beginning. So these two principles have been there from the beginning, but the last one not. And you will see how it evolved, how the international community and international law in general, its mechanisms and instruments evolved to also introduce this principle as irrelevant. So as opposed to this claim that international law is universal, you also have this other option to consider international law as Western, white, and male. Why Western? Because international law was made by Western European states. In the beginnings, it was actually called European international law because European states were the ones to create the League of Nations as the first universal international organizations. And afterwards, the UN situation was a bit different. But again, the European states were the ones to lead the way. White, again, quite obvious. Male, you will see from some of the slides and some of the photos that I have that this was also the case. Okay, I sent you some materials to read. I don't know whether you had a chance to read them. It's not important, but what I have this in mind with this slide is, and why I sent you these different materials, because there you will find quite opposite views of the role of international public law when it comes to gender equality. So if you read this article by Hilary Charlesworth, Christine Chinkin, and Shelley Wright. By the way, Hilary Charlesworth is one of the ICJ judges. So she's currently the judge of the International Court of Justice, elected from Australia. Christine Chinkin, another very famous author. So what they claim in their article published in American Journal of International Law is, I quote, "The structures of international lawmaking and the content of the rules of international law privilege men. If women's interests are acknowledged at all, they are marginalized. International law is a thoroughly gendered system." They also say that international law is pervasively gendered, or more specifically, male-gendered, conceptually, procedurally, and substantively. So this is their position. On the other hand, you have the other article published in Human Rights Quarterly, and the author says that international law is neither conceptually nor procedurally gendered, and most of its substance exhibits no gender bias. Compared to the legal systems of states, international law is sensitive to the concerns of women and is a progressive force for advancing women's interests. So two quite opposite statements, opinions. I won't ask you about your opinion now, because I will have this slide towards the end of the presentation. So think now, what is your position, whether you are more in line with the first one or the second one. And after my presentation, tell me whether you still think the same or you changed your opinion, okay? Now, what will be the issues that we'll be discussing this evening? I'll first go through some gender-neutral origins of public international law. Then we will talk about the normative structure, meaning sources of international law, meaning international conventions, different in the international treaties, and we'll assess their gender sensitivity. So whether there are specific provisions that are gender responsive and sensitive contained in them, do they include gender aspects at all? So this will be the second issue. The third one, we'll go to monitoring mechanisms, to different international organizations, different bodies at the UN level or regional level, and we'll see how they can be used in achieving and advancing gender sensitiveness. And also what we will be discussing throughout the presentation is gender sensitivity of different branches of public international law. They are not all equally gender sensitive. So, gender neutral origins of public international law. It's developed from gender neutral to a branch of law that actually considers gender. This evolution was slow. It took time, but it did happen, and you will see that through the presentation. So this was a gradual and slow-paced development, but what we can also say at the very beginning is that gender aspects are not evenly present in all branches of public international law. My first question now is, which branches of public international law do you know? And what do you think are the reasons for this uneven presence of gender generally in public international law and in certain fields of international law in particular? But let's start from the beginning. What are the branches of international law? Which particular areas of international law can you think of? International humanitarian law, that's right.
Sorry, I had another one.
Also, those who are online, you can unmute and help. What are the branches of international law? We have, Dushanka said, international humanitarian law, international criminal law. That's right. What else?
Something for taxes or economics, something.
There is international investment law, international arbitration law, international tax law as well. What else? But
international.
Okay.
Sorry, international law of human rights.
Well, of course, the most gender sensitive of all of them. That's right, Una. Great. Any others? International refugee law, international migration law, international maritime law, international space law, international environmental law. We now have even international climate law as a part of international environmental law. Some say that it is actually a different discipline. So you can see how many of them there are, and they are not all equally gender sensitive.
International maritime law also.
Which one? I couldn't hear you.
International maritime law. Marine law. Actually.
Maritime law, international maritime law. That's right. Excellent. And you can see that not all of them are gender sensitive. International maritime law, for sure, not gender sensitive. International space law also. But there are some that are, and in whose sources, so international conventions that contain different provisions relating to them, there are gender sensitive provisions. But generally, why do you think this is the case? Why is this? Why has this happened, first of all, so slowly? And why did it take that much time for international law to become gender sensitive?
Because the majority wasn't concerned.
That's right.
They were privileged enough.
So who creates the rules of international law?
Males for the for the beginning of time.
Males who represent different states. And in different states, you have different situations, different religions, different cultures, different attitudes towards women's rights and gender issues. So it really took time to have some kind of consensus, because international law is based on consensus. And as I said, the willingness of states to take commitment. Still, even if you have a treaty that is very advanced in the sense of achieving gender equality, it is progressive, it contains relevant rules. It is really questionable how many states you will have as parties in such a treaty. So states try to balance their interests and will decide whether to enter in a specific international convention or not, based on its particular interest, its own situation, and different other aspects that are relevant in this case. But let's go to the origins. So if you take a look at the origins of public international law, it started with, again, males. Hugo Grotius, Thomas Hobbes, Samuel Pufendorf, those are the founding fathers of international law. They're all males. So legal theory started to be developed by males. If you take a look at the first principles and institutes of international law that developed in this branch of law, they did not have to do anything with women's rights. So it was about states. The Peace of Westphalia after the 30 anything else. War, peace. Those were the things that they were interested in. Diplomatic relations. So for quite a long time, international law was actually the law of diplomacy. Territory, state, sovereignty, law of the sea, international treaties. So these were the issues. These are the classical topics of international law. No particular space for women's rights and gender issues. But then things started slowly to change. And what you have here on this first photo is back in 1888, so the end of the 19th century, when 53 different women's organizations from around the world met in Washington, D.C., and they created the so-called International Council of Women. So you can see that at the end of the 19th century, there were certain women organizations that tried and started to advance, or actually tried to protect women's rights and advance those topics on the international agenda. After that, we had the 1919 and the creation of the League of Nations, the first universal international organizations. You can see the photo from the conference in which the covenant of the League of Nations was adopted. Can you see any women there? No. United Nations, 1945, so not so long ago. And still, again, take a look at the photo from the San Francisco conference, all males. Just a brief remark on the League of Nations. So women's organizations were present there. They participated at the so-called 12th meeting of the League of Nations Committee at the Peace Conference in Paris. But what were the topics reserved to them? They were not among the ad hoc committee which created the League of Nations Covenant. So the most important treaty establishing these organizations and stipulating the mandate of the organization and the issues that it will be dealing with. No women there. only men. So there were 80 members from 13 delegations chaired by US President Woodrow Wilson, but no women there. The topics reserved for women were the following: women's employment rights, prostitution, prison reform, child marriage, trafficking of women and children, all important issues. But they were allowed to discuss on the margins of the conference all the issues that were related directly to women. The Women's Charter was presented at the conference in Paris, but again, only the issues that were, and this was not an obligatory document, so it was just a charter that was a way for women to be heard or to just put on paper those issues that are relevant for them. United Nations, a situation a bit different, but not that different. You can see here on the slide that out of 800 delegates at San Francisco conference, only 8 female delegates. And there was only one country, this was Great Britain, that sent 2 female delegates. However, there were some very important ladies among them, owing to whom we now have international human rights law. And this is Eleanor Roosevelt, who was appointed by US President Truman as the member of the US delegation. And why was her work very important? Because she chaired the UN Commission on Human Rights. So the subsidiary body of the UN, particularly dealing with human rights, we had a woman on top of it. And she was the one, we will see later, who we can thank the wording contained in the Universal Declaration on Human Rights. So this was the first topic. So these gender-neutral origins of public international law, reasons for that. Now we come to the second issue, normative structure. So do public international law norms include gender aspects, and to what extent? How I will structure the presentation, I will first go through some core public international law instruments. Then we'll see what is the situation with core international human rights instruments, because if you remember, and as Una said, international human rights law is actually the most gender sensitive of all branches of international law. Then I will especially focus on international instruments that focus on women's rights, because there are several treaties that are specialized in protecting rights of women. And then we will go also through many other different instruments that are also relevant for gender equality issues. So first, core public international law instruments, which are the Covenant of the League of Nations and the Charter of the United Nations. I selected two provisions, and I would like you to take a careful look at them, because I want you to compare them and to tell me how you perceive them. Take a look at Article 7 of the Covenant of the League of Nations. So these are the only 2 provisions that mention women. No other provisions in either of them that mention women. So Article 7 of the Covenant of the League of Nations says all positions under or in connection with the League, including the Secretariat, shall be open equally to men and women. On the other hand, you have the Charter of the United Nations. Article 8 says the United Nations shall place no restrictions on the eligibility of men and women to participate in any capacity and under conditions of equality in its principal and subsidiary organs. So if you take a look at them, the wording, the formulations, which one do you find more progressive? Shall be open equally, or shall place no restrictions? Which one sounds better? Open, of course, because the other one appears to be less encouraging. There are no restrictions, but it's not the first one. It is open equally to anyone. So it's very strange that the provision that was contained in the Covenant of the League of Nations, so after First World War, is more progressive than the second one. I mean, essentially, the effect is the same. You do not have quotas. You do not have gender parity in any way. No, but the very formulation is much encouraging and more proactive in the first one than in the second one. There is another aspect to consider also. You know, the Article 7 of the Covenant, all positions under or in connection with the League. Whereas in the Charter, what do you see? Principal and subsidiary organs. I don't know how familiar you are with the UN system, but UN system is huge. Principal and subsidiary organs are only one small portion of them. There are many, many, many others. So this also sends a clear message. And have in mind that when it comes to core public international law instruments, these are the only two provisions, of course, besides Article 55, which is the classical non-discrimination provision, but again, not enough. Now, if we take a look at the core international human rights law instruments at the universal level, we have the basics, 1948 Universal Declaration on Human Rights. And again, the lady that I mentioned, Eleanor Roosevelt, why is she important? Because initial text, the draft text of Article 1 was supposed to be worded, all men are born free and equal. And thanks to her, it was changed in the last minute. And now we have this final formulation, all human beings are born free and equal. This first solution sent the clear message that women are politically invisible. There are only men that matter, not women. However, with human beings, the situation was better, not perfect, but better. Then you have Article 2, which provides that everyone is entitled to all rights without distinction, among others of sex. Article 16 is relevant. It proclaims equality of spouses. And Article 25.2 protects motherhood. Now, before I go to the other ones, is Universal Declaration of Human Rights obligatory?
No.
No, that's right, because this is not an international convention. This is not an international treaty. This is actually a resolution of the UN General Assembly. It's called Universal Declaration of Human Rights, but essentially it is soft law. It's not legally binding. However, have in mind always the possibility that some soft law instruments with time become another source of international law, and that is
The second one.
the second one, which was Dushanka?
International
Customary law, international customary law. So what you can find today in the writings of numerous scholars is the position that what is contained in Universal Declaration, so it's subject matter, regardless of its form is not obligatory, but what is the content of those provisions, they claim, and I agree, today is considered customary international law. So it obliges all states, regardless that formally, from the formal point of view, this is not obligatory. This minor problem regarding obligatory status of this instrument was resolved in 1966 with two very, very important international human rights instruments, core human rights instruments. These are the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights. This is the so-called bills of rights in international human rights law. What do we have here? Article 2 that stipulates that states will respect and guarantee everyone within their jurisdiction all rights without distinction of any kind, including sex. And Article 3 that provides for equal right of men and women to the enjoyment of all civil and political rights. Identical provisions are contained in the covenant which relates to the second generation of human rights, so economic, social, and cultural rights. Other core international human rights instruments, very important one, and we will be discussing all of these instruments in more detail within the course International Human Rights Law and Gender Equality. So these are only the introductory remarks and basics. We will go deeper in that other course. So the Convention Against Torture, 1984. I deliberately took the chronological schedule or list so that you can see how things advance or not. I will we'll go to that later. So the Convention Against Torture, maybe you would be surprised, but this is 1984. So in 1966, we had at least this general anti-discrimination provisions. Now, no gender-sensitive provision, and even the wording used is person, him, not him, her, but person or him. 1989, the Convention on the Rights of the Child. There are relevant provisions. Again, the classical anti-discrimination provision, which mention child or his or her parents or legal guardians, race, color, sex as a ground for discrimination, etc. And also Article 29, which provides that states parties agree that education of the child shall be directed to the preparation of the child for responsible life in a free society in the spirit of equality of sexes. So these are, again, the only two provisions that might be considered as gender sensitive. 1990 and the International Convention on the Protection of the Rights of All Migrant Workers. Article 1, Article 7, again, some provisions that can be considered gender sensitive, the classical non-discrimination provision, which raises sex as a ground of discrimination, but also marital status, which is relevant when it comes to women. And Article 7 that provides that states parties undertake in accordance with international instruments concerning human rights to respect and to ensure to all migrant workers and members of their families within their territory the rights provided for in the present convention without distinction of any kind, such as sex or marital status. So again, these are the only two gender-sensitive provisions in this instrument. And the most recent one dates back to 2008, the Convention on the Rights of Persons with Disabilities. The situation quite advanced. We have more provisions that deal with women's rights and actually rights of women with disability. Why is this important? And we will insist on that, this intersectional approach, because not all women are in the same position. Women are in themselves are vulnerable, but there are some categories of women that are more vulnerable than others. So there are many layers of vulnerability. Have in mind, for example, a woman which has disability, or women which is an elderly woman and a woman with disability, or add another layer of vulnerability. Just think of a woman who is a woman with disability, an elderly one, and a migrant. So outside its country of origin. Different layers of vulnerability are there, and this intersectionality approach should be applied all the way. This was recognized in the Convention on the Rights of Persons with Disabilities, but still this is the very subject matter of this convention. It deals with persons with disabilities. However, what is a good thing is that it considers the vulnerability of women with disabilities in specific provisions. Here on the slide, I have this Article 6, which actually is directed towards women with disabilities. So states parties recognize that women and girls with disabilities are subject to multiple discrimination, and in this regard shall take measures to ensure the full and equal enjoyment by them of all human rights and fundamental freedoms, etc., etc. Article 16, freedom from exploitation, violence, and abuse. again, including women and child-focused legislation and policies, adequate standard of living, Article 28, and social protection, again, to ensure access to persons with disabilities, in particular women and girls with disabilities. So you can see that there are several provisions that deal with women's rights. Now, that you have an overview of universal instruments when it comes to core international human rights law instruments, do you have any conclusions as to gender sensitivity of core international human rights instruments at the universal level? What can you conclude from this brief overview of the provisions that are gender sensitive and contained in them? Not much.
It's very, very superficial and maybe just the color as it is. And I guess a lot more thought needs to be put into it.
And who does that? Who does that? Actually, these instruments that I mentioned, you see how scarce and how not precise enough these provisions are when it comes to considering gender or women's rights. But who takes care of the implementation of these treaties?
Different bodies.
Yeah. So all of these treaties that I mentioned, they have their treaty body. Convention Against Torture, there is a committee, UN Committee Against Torture. Convention on the Rights of Persons with Disabilities, there is a Committee on the Rights of Persons with Disabilities. Convention on the Rights of the Child, there is a Committee on the Rights of the Child. Covenant on Civil and Political Rights, there is a committee which is called, and this is the most important one, anyone online?
Can you repeat the
Covenant on Civil and Political Rights, the one from 1966, the first and the most important one. Why? Because its subject matter is wide. It treats all human rights, not just rights of particular groups of people. Human Rights Committee, the one with the widest jurisdiction, widest mandate. You have the Committee on Economic, Social and Cultural Rights, which oversees the implementation of the Covenant on Economic, Social and Cultural Rights. Now, why are they relevant and in what way do they contribute to advancing women's rights and gender equality despite either scarce provisions or a lack of provisions? In what way? What do they do? How can they help? Implementing them. So through mechanisms that they have at their disposal. Meaning what? What they can do is all state parties need to send reports. So how do they implement in their national practice and national legislation the obligations taken by that particular treaty? And they send the report. The report will deal with women's rights as well. Then the committee revises that and they say, okay, you are doing this fine, but you are not doing this fine. Another thing, they have the so-called general comments. This is an overview of the standards regarding a particular matter and what you can find within their general comments. Some of their general comments or general recommendations, sometimes they are called general comments, sometimes general recommendations, they actually deal with women's rights. So you have, for example, a general recommendation from the Committee on Torture, which deals with rights of women deprived of liberty and relevant standards that should be applicable to them, even though in the Convention Against Torture, there is no mention of women's rights and the how torture differently impacts women and men, and what are the gendered aspects of torture and inhuman degrading treatment. So you can see that despite the fact that some of them do not even mention women's rights, or the provision provisions they contain are very, very.
But is there the question whether this law is gender sensitive or this practice is gender sensitive? Because the law itself, with him and okay person is a good term actually, if we have a man on the other side as any other. So therefore, I would say that this one, the law, it's not gender
It's
sensitive,
not.
but the practice.
But you can make it.
But
Yeah.
there are people who are sensitive to it. So
That's right.
that can be that in the future when we don't have gender sensitive people in that committees, in that bodies, that means that.
But never mind, we have general comments. You know, general comment, general recommendation will be there forever. You know, yeah.
It's just like
You are fine. I mean, take your position. You're right. It depends on who you have within those bodies. But in those bodies, those are international bodies that treat human rights.
No, I mean,
you always have people who are, I mean, experts who are sensitive for human rights in general and women's rights in particular. Of course, some more, some less. But and also not all human rights bodies are equally prone or open to discussing these issues, but there are other avenues as well. You will see. What I wanted you to have in mind here is that the fact that you do not have explicit provisions contained in those treaties does not mean that they should not be interpreted in a gender-sensitive way, and that has not occurred already. It did, because, and I'm calling upon you to visit the website of the UN treaty bodies. You have all of them on the website. You have all of their general recommendations and general comments. You will see that they do treat and they do establish very, very particular, very concrete standards when it comes to women's rights. Through them, we will go in the human rights course, because that will be an opportunity to go into more details regarding specific general comments and general recommendations. This is just an overview, just something to have in mind, that these norms are not static. They are dynamic, they change, because they are always interpreted in light of the present conditions. This is something that European Court of Human Rights does regularly. The European Convention, if you take a look at those rules, I mean, they're concise. There is not much in them, but then the court is the one who interprets them, and the court interprets them in light with the present day conditions, meaning the topics that we are today interested in. Okay, is that clear? Do you need a break?
Yes. I just wanted to add that the maybe how do you say applications or complaints by individuals or group of individuals to special rapporteurs or committees that can also be can also kind of put a flag on some gender topics to the bodies of UN.
That's right. I will come to special procedures later. I did not want, because I can see that we have students who are familiar with international law and its mechanisms, but there are some that are not. So I'm taking it slowly. For the moment, just an overview of these treaties and treaty bodies. But yes, Una, thank you for reminding me. This is another opportunity for treaty bodies to interpret these provisions in a gender-sensitive way, because when an individual sends an application to a UN treaty body claiming my state or the state under whose jurisdiction I was when the violation happened violated a particular provision of that treaty, the conclusion, the decision of the committee can send some very clear standards when it comes to reading these particular provisions in a gender-sensitive way. So this is also an option. Through concluding observations when treaty bodies examine reports, through individual communications and conclusions taken in that regard, and through general comments and general recommendations. Again, question, do you need a break?
Maybe 5 minutes.
5 minutes. Dushanka and Ksenia say 5 minutes break. Yeah, it's now 7:35. Maybe you can go have some, grab some water, coffee, or whatever you need, and we'll be back in 5 minutes. Okay?
Okay.
Da li znate možda gdje kako se postavila ove dodatne kopije? Točno da pitam.
Samo da slala isto u Lindu. Imaš nešto sada?
Tamo, nego je to ostalo sam.
Da, ali sad
Evo modula. Opa.
ja se ne znam uspala da se ne. Ali onda kad čiste te kredencijale tamo u modu, kaže invalid, znači se da
A potpuno na povijek evropske granice, vidjet ćete kome ćemo znati.
ja super da ih uzmem. Baš da ću da vidim. Bila je isto u ovoj granici.
Bilo je ok, ona i dvoje tako da je plan boju.
Dok se odlučiš novog Beograda,
বাংলাদেশ থেকে আসছি আমি এখন আমাদের বাংলাদেশের পক্ষে কাজ করতে চাই বাংলাদেশে চলে যাচ্ছি
se ne vraćam.
Da, ne važno aplikaciji Lanes, ali fleksibilno radno i ja da je što mi je pisao da ja volim se pa smo to znam,
ali dobro, ne su. Nije bilo prepravno bitno
osnovi neki kontrata, oni su imali. Tako da će biti to na mnogim što ovo.
Čekaj, ovo ne si spremati ono što ne.
Ovo je njega svašta.
To sam mislila. To sam sve radila preko Bilsku.
Da.
Šta je bilo na kraju zaključka? Dobro, ja sam potpisala s onom djecu kao zimska literatura, vama tamo.
Kako se koristi gorak? To smo radili. Da. Ono, što imaš ono, kako treba da informativno vremena. Tako da imali bukvalno stvari, kako se pravilno stavio, take break, tako se neke stvari.
I to je bilo.
I to je bilo, da.
Znači, nije bilo nečeg nekog materijalnog.
Ne. Ali kao imaš šutu. Biće dobro. Šta se da ne tako? To znaš.
Hvala ti.
Ništa.
মামুন বলো। আমি ক্লাস করতেছি, আরো আধা ঘন্টা পরে ফোন দাও মানে, ঠিক আছে? আধা ঘন্টা পরে কল দিও। আমি 8:20 দিয়ে কল দাও, 8টা তুমি জাস্ট 9টায় কল দাও, 9টায়। আর তোমার এখানে কয়টা বাজে এখন? হ্যাঁ, সকাল 9টায় কল দাও। হ্যাঁ, এবার সকাল 9টায় কল দাও।
For you who are online, just to know, I have some sweets here in the ride. Yeah, so next time you might consider coming to the faculty, because there will always be some sweets at my classes. Okay?
Thank you so much.
Just a joke. Are you there? Can we continue?
Yes.
Yes,
We can continue.
you can continue.
Okay, excellent. Are you tired?
No.
Oh, fine. So this was the universal level. Now let's just briefly take a look at the regional level, the Council of Europe. The entire second part of the course dealing with EU law sources. I will just focus on Council of Europe as the relevant regional organization that focuses on the protection of human rights. So the most important treaty, European Convention on Human Rights. It does not protect women's rights explicitly, but there are two provisions, of course. All the rights contained therein are to be enjoyed by women as well. I mean, they are guaranteed to anyone. But we have two relevant provisions, the anti-discrimination provisions, Article 14, which is not a standalone right. I mean, the court, if you, as a party, as an applicant, if you go before the European Court of Human Rights and invoke Article 14, you always have to link it to another ECHR provision. So you cannot just go and claim Article 14 is violated. You need to link it to, for example, Article 2, Article 3, or 8, etc. As opposed to Article 1 of Protocol number 12, which is also an anti-general prohibition of discrimination provision, which is a standalone right. So it applies to those states who ratified the Protocol number 12 to the European Convention on Human Rights. When it comes to the 1969 American Convention on Human Rights, so the regional treaty in the American continent, Again, in Article 1, obligation to respect rights, just the classic general anti-discrimination provision, nothing else. But when it comes to the African Charter on Human and People's Rights, the 1981, so the most recent one, there is a particular Article 18 that provides the state shall ensure the elimination of every discrimination against women and also ensure the protection of the rights of the woman and the child as stipulated in international declarations and conventions. So based on this brief overview of regional human rights instruments, core human rights instruments, are there any conclusions that you can take as to gender sensitivity of them? I will go back to this slide. So which appears to be the most gender sensitive from all? Out of three of them, the three regional ones.
The African Charter.
The African, definitely. But does it mean that this is a good thing? I mean, does it ensure the adequate protection of women's rights?
As far as I know, that is the word.
No, this is the weakest regional human rights protection system of them all. The African Charter on Human and People's Rights does indeed have certain very progressive and good provisions, but the implementation is the problem, and the mechanisms for ensuring the implementation. So the African Commission on Human and People's Rights and the African Court on Human and People's Rights, I mean, they are not that influensive as the other two. Of course, the strongest one, if I may say that, is the European Court of Human Rights, because it also has different ways to ensure the execution of the judgments. Again, not perfect system for sure, but there are some things that can be done in order to push the state to execute the decision. Another difference, if you compare them, the African Charter refers to women's rights as stipulated in international declarations and conventions. So it refers to other international conventions and declarations, which is a specificity of the African system. The European Court of Human Rights, it only oversees the implementation of the European Convention on Human Rights and the rights guaranteed therein. Of course, it is influenced by certain other international instruments when it interprets the provisions of the European Convention. For example, it regularly refers to the Istanbul Convention. Have you heard about the Istanbul Convention, the one that fights against gender-based violence and domestic violence? Also the CEDAW Convention. So when it has a case dealing with women's rights, it will refer to those treaties and to the jurisprudence of the bodies overseeing their implementation. However, it is not obliged to do that. On the other hand, you have the African Charter, which explicitly links the protection of women's rights in Article 18 to other international treaties and declarations. Fine. The final part, when it comes to the normative structure, are those instruments that particularly focus on women's rights. And on the level of the universal level, the level of the United Nations, the most important one is CEDAW, and we will be discussing So it was adopted in 1979. It generally prohibits discrimination, gender discrimination, but it also lists women's human rights to equality and non-discrimination. I selected Article 7. As I said, we will go through this last 7 is equality must be implemented in public and political life, enabling their participation in non-governmental organizations and associations and securing a more active role in international organizations and state delegations. Why I deliberately selected this particular provision because our next topic will actually be participation of women in different bodies at the universal level, so within the UN system. So you see that Article 7 actually guarantees that equal participation and more active role in international organizations and state delegations. I will skip this. You might be familiar with that. We have a specific course, I think, elective one, dealing with labor law and women's rights. I don't know whether you are interested in it or not, whether you selected that course, but have in mind that international labor organizations, as a specialized agency of the UN, has a number of international conventions which deal with women's labor rights, harassment and violence at work, maternity protection, etc. So there is a number of international conventions relevant for women's rights adopted within that convention. And last but not least, the regional level, when it comes to those treaties that focus on women's rights. First of all, the 2011 Istanbul Convention. So it was the specialized convention, it is the specialized convention, which was adopted within the auspices of the Council of Europe, and it provides a set of obligations for states regarding gender-based violence and domestic violence. Does it have an overseeing body? A body, the Grevio, the expert group, which oversees the implementation of this convention. This is not a treaty body, so individuals cannot send applications to Grevio, but Grevio goes to particular contracting parties, checks the situation regarding normative framework, practice, etc., and then gives a specific report, opinion on the situation in that country and whether the state is on track with its obligations or not, and what are the issues that it has to improve or resolve. The similar convention at the American level is the Convention Belém do Pará, and also at the level of the African Union, the African continent, there is the Maputo Protocol. So they all are regional conventions dealing specifically with women's rights. You remember the slide at the beginning. So we had core public international law instruments, core international human rights law instruments, core women's international conventions, in women's rights conventions, and then there was other. So what is this other? Well, generally anything else. So all the conventions that relate to the particular areas of international law that we mentioned. Next Wednesday, we'll talk about international environmental law. I don't know whether you are environmentally conscious, whether you consider environment and environmental protection as an important thing. But for example, the Paris Agreement on Climate Change has very, very important provisions that focus on women and their rights and the fact that climate change impacts women and men differently. Last April, the European Court of Human Rights delivered the first climate change decision, and the application was submitted by a group of elderly ladies organizations. So their argumentation was that climate change affects older women differently than others, and that Switzerland, by not implementing its Paris Agreement commitments, violated their human rights. So you can see how maybe at the first sight you would not connect international environmental law with gender equality, but it is. And it is more and more relevant, and there are some very interesting provisions that we will go through. You will deal with criminal law and humanitarian law with Professor Kristic during her classes, and for example, refugee law we will talk about in human rights books. So you will see that it also has some very important both instruments and issues to deal with gender equality. Soft law, you remember anything which is not binding. but do not neglect their relevance, because if you remember, those obligatory provisions, which might not be gender sensitive, can be interpreted as gender sensitive through soft law instruments, through general recommendations, general comments, conclusions of treaty bodies, reports of special rapporteurs, etc. So these are all soft law instruments. They're not binding, but still they are influential. So they are relevant in terms of building international standards on a specific issue, and interpreting relevant obligatory provisions. Something just briefly, I will send you the presentation and you can go in details through these couple of slides. But I would like to remind you that gender equality is one of the sustainable development goals, which means that achieving gender equality and empowering all women and girls is one of the goals of the international community. Every sustainable development goals, there are 17 of them, has specific targets. So some issues that have been identified as problematic and in which states are to put more effort and progress in order to achieve the results. I will not, as I said, go through all those targets. You can do it on your own at home. But what is really discouraging, to say the least, is the current figures and whether the world as a whole is on a good track or not in meeting those targets to achieve gender equality as a sustainable development goal. Sustainable development goals, they were adopted in 2015 and they're expected to be achieved by 2030. That was the idea when they were adopted. We now live in 2025. It is coming to an end. Soon it will be in 2026. And you can see the results so far. The world will need another 300 years to end child marriage. The world will need another 286 years to close gaps in legal protection and remove discriminatory laws. We will need 140 more years to achieve equal representation in leadership in the workplace when it comes to men and women, etc., etc. 1 in 5 young women are married before their 18th birthday. These are figures that relate global. I mean, they're global. You will have on some other slide other numbers. I mean, numbers sometimes speak for themselves, and they can tell us a lot. And all the figures that you have here are very, very disappointing and discouraging when it comes to the current status of women and women's rights in the world. Gender equality is a specific sustainable development goal, but have in mind that it is actually connected to almost all others. Because take a look, sustainable goal number 1, no poverty. It has to do something with gender equality, because poor women from rural areas who deal with agriculture, etc. I mean, there are gender equality, inequality issues there. The same goes with almost all other, maybe 14, and SDG 14 does not have, like below water, it does not have anything to do with gender equality, but all the others do have much to say. An equivalent to SDGs, which are global and they relate to all human rights, is the so-called Beijing platform. This is in a way SDG, but only when it comes to women's rights. So it was adopted in 1995 in China. That is why it's called Beijing platform. And it is actually an agenda for the empowerment of women. It has, again, certain goals set by these 198 states, many of them, almost the entire international community, but they set certain goals that they would like to achieve through, again, certain targets. And it covers 12 critical areas. You can see education and training, health, violence, armed conflict, economy, power and decision-making, institutional mechanisms, human rights, media, environment, and the girl child. So these are the areas that were recognized as relevant for empowering women, and then some strategic objectives and actions that should be taken were identified. But again, this is soft instrument, soft law instrument. I mean, it's not obligatory. It's some kind of a pledge that states 189 of them took. However, again, the results are not that promising. You can see that, for example, just take education. All developing regions have almost achieved gender parity in primary education. But gender disparities at the secondary and tertiary school levels in many countries. So we now have women in primary schools in most countries, but the higher levels of education are not that accessible to women. The same goes with wages, for example. At least 50% of the world's women are in paid wage and salary employment, which is an increase from 40% in the 1990s, but women earn 10 to 30% less than men. And what we all know, I don't know about Alexander and what was the name of the site, whether you are aware of that, but women do 2.4 times more the unpaid work, meaning domestic work, than men. So we really use much more of our free time, again, doing work which is not paid. And also, when it comes to salaries, women earn less than men, etc., etc. So you can take a look at those figures. They're very indicative. Okay, I can skip this one because you will have international humanitarian law and criminal law with Professor Kristic. You will go through this resolution with them. At the regional level, the Council of Europe did establish the gender equality strategy, which concerns period 2020 or 2029. Now, totally or soft law instrument. Soft. That's right. So these are again some pledges, some strategy, actually actions that now Council of Europe countries intend to take in order to achieve gender equality. But again, it is not obligatory, and you can imagine that different Council of Europe states achieve those goals and take those actions at different paces, depending on many reasons. Okay, I will skip this as well. Now, the third topic for this evening, so we are coming closer to the end, was, if you remember, the institutional aspect. So let's see how many women are there within the United Nations and in relevant bodies that make decisions globally. So when you think of the United Nations, which person do you associate it with?
That person, you mean like man or
a person? So UN. Which person? One person is the first one that you think of. Who personifies? Who represents the United Nations?
When I think about United Nations, I think about security. To be honest.
Okay, but Security Council, this is a round table. There are many of them. You cannot think. I'm sure that you're not familiar who is the current ambassador of the U.S. in the UN or of Russia in the UN Security Council. But who is the one person that is actually representing the organization? Anyone online?
Secretary General.
Excellent, Una, thank you. The Secretary General of the UN. And now take a look at this. So throughout the history of the United Nations, there have till today 9 of them. But any ladies? No. Are any of these faces familiar to you? I'm just curious whether you know them.
I heard about them.
Guterres, okay. You know about Antonio Guterres, the current Secretary General. But you know, this is important. The fact that you have not heard about him says much about his the influence that he has in the international community. Because back in when, for example, Kofi Annan or Boutros Ghali were living, you remember that. But back then, everyone knew about Boutros Ghali. Everyone knew about Kofi Annan. Even you, now that I mentioned their names, you heard about them. Well, whereas Antonio Guterres, I mean, he's not that influential, and as I said, it speaks a lot about him. When Ban Ki-moon, when his mandate was approaching to at the end, he very much, what's the word? He actually stressed the importance to have a woman as the next Secretary General. And on the list, candidates of Antonio Guterres were some ladies, so there were some other, besides our Vuk Jeremic. Remember that he was also the candidate when Antonio Guterres, yeah, you forgot that. So there were also some ladies, but still this did not happen. You have the 10th one and many question marks. We'll see whether maybe the next Secretary General will be a lady. But until then, what I would like to go through briefly is some bodies within the UN systems that are important for women's rights. So, as I said, UN system is a huge system. Many principal bodies, many subsidiary bodies, many different departments within the Secretariat, or many bodies within other bodies or commissions, committees, etc., etc. So a huge system. Not all of them are relevant for advancing women's rights and protecting women's rights, but what I selected as relevant, and they are relevant because of their mandate, are the following. The United Nations Economic and Social Council. Why is it important? Because it is the principal body of the UN, which has a mandate, the largest mandate, the widest mandate when it comes to human rights. Human rights in general, but it goes without saying women's rights as well. Have in mind that this is a principal body of the UN. There are not many principal bodies of the UN. Can you give me some other principal bodies of the UN? We mentioned several already.
Human Rights Council?
It's not principal, it's subsidiary, but principal bodies, they are not that much important for women's rights, but just I'm curious, I mean, there are not many of them. We mentioned which one? The International Court of Justice as a judicial body. There is the General Assembly, where all states are present. There is a Security Council that Chilushenko mentioned. And there is the Trusteeship Council, but this one is not important anymore. When with the colonial era behind us, it lost any power. And there is the Secretariat as the administrative body. So these are the only principal bodies. Among them, you have the ECOSOC, the Economic and Social Council, as the most relevant for women's rights. Then we have the UN Commission on the Status of Women. Maybe you have heard about it or not. This is the subsidiary body of ECOSOC dealing particularly with women's rights. Then you have the United Nations Human Rights Council, the one that Una mentioned. But this is the subsidiary body of the UN General Assembly. So the General Assembly is a big body. So all member states, all delegations are there. You cannot expect the General Assembly, even though it has the widest mandate within the UN system, to be very effective when it comes to human rights. So what the General Assembly did is establish a special body to help it within this particular area of human rights protection, and this is the Human Rights Council. It is very important for women's rights as well. Then we have UN Women. You must have heard about it. This is a part of the UN Secretariat. And last but not least, CEDAW. CEDAW is the treaty body. So it is not institutionally a part of the UN system, but it is linked to it. So it was not established by another body of the UN, but it is a treaty body. It was established by the Convention on the Elimination of All Forms of Discrimination Against Women, so the state parties to that convention. Now, what I want you to think about when I go through them, and I will explain them briefly, is first of all their mandate. So which bodies deal with which issues, and how relevant, how important, and how powerful a particular body is. Then think about the status of that body, whether this is a principal body or a subsidiary or other. And finally, but very importantly, think about the composition. So how many women and whether there is gender parity there. And then we will be able to draw some conclusions when we go through them. So the first one was ECOSOC. You remember, the principal body of the UN, one of the main bodies of the UN, that deals with human rights in general, but also women's rights. Its mandate is to promote social and economic progress, health issues, human rights without discrimination based on sex, among other grounds. You see the gentleman here on the photo. So he is the president, current president of the ECOSOC, and he's from Nepal. Do you find anything interesting in that fact that the president of the body, the most important body within the UN, comes from Nepal?
I think that they use the value of geographical aspect.
That's right.
That it's good to not be centered Western area.
I totally agree. But what is the present situation with human rights in Nepal?
But still, if we use that just be a core for you have merits to be on this position, and then we will have only maybe 2 countries, maybe from Islam or and that's not unfortunately representation, the whole representation of the world.
Yeah, I understand fully your argument. Before Lok Bahadur Tapa, I'm not sure whether I pronounced his name correctly, but one of the former president was a woman from Chile. Again, you have a peculiar situation. You have a woman on top of this very important body, but coming from a country which does not have a great record when it comes to protection of human rights and protection of women. Yeah. But again, you were right. The main criteria is equitable geographic representation. However, when it comes to this body, this does not have to be a problem. But take a look at this one. UN Commission on the Status of Women. You remember, this is the subsidiary body of ECOSOC. Now, ECOSOC, again, it has a mandate regarding all human rights, but it cannot deal effectively with all of them on its own. So it decided to create a subsidiary body, the UN Commission on the Status of Women, and that commission is supposed to deal and work on the advancement of women's rights among UN member states. Do you have any idea why I put this photo on the slide?
The second one.
The second one. Because currently, the chair of the UN Commission on the Status of Women is the representative of Saudi Arabia. So, do you find that problematic?
More than
the one. Yeah. And this was really, in the international community, because it is always announced 1 year in advance who will be the chair for the next session. So last year, this time, when this information was out that this particular person, I don't remember his name, it's a he, Abdulaziz Al-Basil from Saudi Arabia, that was, a shock, especially for...
What way are they choosing? They have like a program or just like qualifications, and then they randomly...
Equitable geographic representation, and then you have candidates from different regions, and then other countries vote. Yeah. So a lot of lobbying, different kinds of pressures. We think that maybe things function in that way only here, but no, actually there are other ways to achieve certain results. But this was really, as I said, perceived as absurd and problematic, especially from the part of those who advance human rights and deal with human rights. Having someone from Saudi Arabia, a male, on top of the UN body, which is the most specialized one for protecting women's rights.
Does it affect its work?
We'll see, because this is currently happening. I mean, the session for 2025 is now ongoing. At least nothing will be done. I mean, but you lost some valuable time in meanwhile. UN Women, we really owe a lot to UN Women in the creation of this master program, because UN Women was one of our allies in the course of preparing it. They supported different summer schools and other events that we were organizing while we were doing the capacity building of all of us. Gender equality and women's rights were not issues that most of the teachers that you will have within this master program were specialized in. But throughout these years of preparatory actions for the establishment of this master program, we also learned a lot and started to be very enthusiastic about these topics. So UN Women, but if you remember, this is the part of the UN Secretariat, and currently we do have a lady on top of this body. Now, something that Una mentioned, and a very important one, Human Rights Council. We will be coming to this one very often, so I will now take a few minutes to explain the way it works. So Human Rights Council, if you remember, is the subsidiary body of the UN General Assembly, specializing in protection of human rights. What is important is its mechanisms. So one of the mechanisms is the so-called complaint procedure. A person from any country can submit a complaint to the Human Rights Council against any state, meaning even those states that are not parties to international conventions. So if you have a state which neglects the protection of human rights, it is not party or is not anymore the party of a particular international treaty. The only mechanism that you have at your disposal is through compliant procedure before the Human Rights Council. Another positive aspect of this procedure is that this is confidential. So why is it relevant? Because it enables the Human Rights Council to negotiate with a particular state the outcome of the case. Sometimes the state will not be happy for the rest of the world to know about this particular case and problem, and it will be willing to make some compromises and maybe provide some compensation, satisfaction to the victim of human rights violations. So this is the complaint procedure. Then there are special sessions. So, for example, if there is a particular problem with the situation in Darfur relating to protection of women, rape and sexual violence, or the Democratic Republic of Congo, these two issues happen. So gender inequality and sexual violence in relation to DRC. Then the Human Rights Council can hold a specific session dedicated to the situation in that particular country, issue certain resolutions, take other actions at its disposal. It's not much. Again, we are talking about some soft instruments and soft responsibility of the particular state which is violating human rights and women's rights, but still, this is something that can be done. Universal periodic review is something that happens, as it is called, periodically. But this it functions in a way that other states evaluate the situation regarding human rights protection in the particular state which is under evaluation. So, for example, when Serbia was within the Universal Periodic Review, there were some other states coming with their remarks and proposals, what to change, what is functioning, what is not functioning within our system. And last but not least, something that Una mentioned, special procedures. So these are either special rapporteurs or working groups, groups of experts who have mandates regarding particular issues. And when it comes to women's rights, there are two most important ones. The first one is Special Rapporteur on Violence Against Women and Girls, the lady that you can see here on the slide. She is current Special Rapporteur. What can she do? A lot of things. Again, soft instruments. So it can pay a visit to a particular country, talk to the authorities, issue some statements concerning the situation in a particular country. Individuals can write to her and signal that there is a problem regarding violence against women in a particular country or the situation that they personally had. So she can recommend measures to the state. Very important when it comes to advancing standards, thematic reports. So the special reporter go to the website, check what are the reports, which topics she covered in the course of her work. Why are they relevant? Because they contain standards. They contain international standards relevant to the particular topic that she decided to focus on and publish. Similar with the next one. I will now move this one.
Click on the corner, left corner.
This one?
No, the other side.
Oh, this one?
Yeah. And then you can just press it and
great. Okay, now I don't see them, but let's... do you recognize some of the photos? The question goes to you online as well. No one.
Fortunately, maybe I cannot.
Una, Alexander, you can see it on your slide, maybe even better than Ksenia and Dushanka here.
I can see it, but I don't recognize anyone.
Anyone. Okay. Now, this is, if you remember, UN Special Procedures, UN Human Rights Council Special Procedures. There are two types: special rapporteurs, so a single person dealing with a particular topic, or the working group. We have the Special Rapporteur on Violence Against Women and Girls, and we have the Working Group on Discrimination Against Women and Girls. One of their members, there are 5 of them, is Professor Krstić.
The blonde one.
The blonde one. the one representing Europe. So you can see that each one of them comes from a different region of the world. Laura is from Uganda. Claudia is from the United States. Dorothy is from South America. Professor Krstic is from Europe. And we have Heina, who is from China. I'm so sorry that this master program started only now, I mean in November, because they all were here in Belgrade at the end of September, beginning October. They were on their regional visit here, but they were located in Serbia. And we spent 5 so inspiring and interesting days with those women. What I want you to know that all that they do is pro bono. So they are volunteering. You know, when people think about the UN, so these are, I don't know, some great salaries, money, etc. No, they do this on. They volunteer.
This is the case for other topics.
Yeah. Oh, yeah.
No other topics. Other topics that aren't related to gender.
Yeah. All special procedures. They are volunteers. They are experts. Mm-hmm. They receive no salary, no remuneration. They can still work, do their usual work. For example, all of them are mostly they are professors, law professors, except Laura from Uganda. She's a human rights lawyer and activist. But everything that they do, and believe me, I know what. I mean, I'm speaking this because Professor Krstic will never tell you this. This takes so much of her time, of their time, and they are doing it pro bono, and they are doing it that because they believe that they are doing something right and something that can bring a change. So, besides this interesting story and new story to you, what they do is similar to the special rapporteur. So they can be, you can submit communications to them, so individuals can send them communications. They draft thematic reports. For example, they have a report relating to rights of women in prisons. Mm-hmm. What they will focus in their next report is digital violence in digital environment. So you can see that they recognize a particular topic as a relevant one, and then they issue this thematic report. Why is it important? Because experts, UN experts, have certain statements and they establish certain standards that afterwards you can use in your strategic litigation or whatever you do in order to advance human or lobbying with national authorities. So invoking their positions on a particular issue is very, very useful. They can do country visits as well. I think that Professor Krstic went to Thailand to a country visit, but sometimes, the destinations are not that nice. I mean, one of her colleagues from the group, she went to Afghanistan. So, it's hard work. It's hard work. And it's really something that they can be proud of, but that we can also be proud of to have her in this position. And at last, the last one. Any ideas? Who are these people? What can you notice? Sido, excellent, Mushika. Yes. What can you notice?
There are more women than men. One man.
Only one man. Yeah, that's right. So this is the CEDAW. This is the treaty body that oversees the implementation of the Convention against discrimination against women, on the elimination of discrimination against women. So they are all, again, experts. And they monitor the implementation of this treaty. I explained already the procedures that they have at their disposal. So reporting, inquiry procedure, individual communications, and general recommendations, very, very useful ones. And we will come to them throughout this course. Now, my question is, any conclusions as to gender parity, mandate, status of international bodies at the universal level? So take it from the most powerful ones, meaning principal bodies, till those that are not that powerful. And those most powerful ones, they do not have very specific mandate when it comes to women's rights. These that, regarding their status, are not that influential, do have broader mandates when it comes to women's rights, and have in mind the gender parity. So how many women are there? What can you conclude?
I mean, it's interesting for the second body that the president is going to be from Saudi Arabia, for sure. But I think that any other that is super-centered and focused on women's issues, and women and CEDAW, is kind of logically set around women.
Yeah.
But for any other that's more general, I think it's easier to have men there, for men to be there.
Yeah.
So gender parity doesn't exist, I would say, in anybody. Even in CEDAW, we have only one man.
That's right.
It is the issue regarding the women. But still, the
women deal with it.
Is outside.
Yeah.
So,
and what you can also see that experts in women's rights are women. We have Alexander. We have Alexander here. We have Taifu. So you will be experts in women's rights as well. But you can see that when it comes to international organizations, international bodies, the ones that specialize in women's rights, they're mostly consisted of women.
I mean, that's a good thing, to be honest. It really is, because the places and platforms for women are not that great. So you just have that is really good.
Professor, I think this must be 50-50. 50 men, 50 women.
Yeah. We can hear you.
I think this must be 50-50. 50 men and 50 women in parity.
Saiful, I couldn't agree with you more, but unfortunately, within the UN system at least, there are no gender parity provisions. So no quotas. This is an old organization, and its rules, especially the Charter of the UN, it hasn't been revised since. There were some minor revisions, but states prefer not to revise it for other reasons, not for women's rights reasons. So unfortunately, this is not the case at the UN level, and you will deal with that with Professor Krstić on Saturday. You will talk about a gender sensitive judiciary. You will talk about how many women there are in international judiciary. So within international courts, the International Court of Justice, the European Court of Human Rights, for example, the European Court of Human Rights, it does have certain rules that tend to achieve gender parity among judges. Still, I mean, they are not perfect. This is not Saiful's 50-50 for sure, but when countries propose candidates for their judges within the European Court of Human Rights, they have to provide a list of 3 names, and there should be both sexes there on the list. So it's a way to try to have more women within the European Court of Human Rights. But still, for example, I didn't check the current situation because there were some new elections. But for example, last year, I remember that among 46 judges of the European Court of Human Rights, only 17 were women. So still, we're not close to 50-50, but we are advancing. With the International Court of Justice, it's more complex, and you can imagine that there are not that men in the International Court of Justice. So, what we can see is that those bodies in the UN system that are more powerful, they are usually consisted of men. If you take a look at the Security Council, which is the most powerful UN body, or the position of the Secretary General, these are, for the Secretary General, all male until today. In the Security Council, you can find some representatives of states that are women, but still not that many. And then, you know, the bodies that do deal with women's rights, their power is not that important. They're not that relevant. And what also you can notice that when it comes to those bodies that specialize in women's rights, women are the majority of the members of those bodies. This is the slide that actually shows this, you know, main bodies, they are the most powerful ones, but then there are less ladies in them, and it refers to others as well. Just for the end, actually oversees the implementation of the strategy. Remember the gender equality strategy within the Council of Europe. We have Grevio as the expert body that oversees the Istanbul Convention, and we have the European Court of Human Rights. Now, since not all of you are lawyers or took public international or human rights law course, just regarding the European Court of Human Rights, do you know how it works? Do you have any?
I know because of the work
that you are doing.
So the applicants can be individual cases as well as the state cases. And you can sue the country and other person if your right from the European Convention is
violated.
So, and then you can that's the state. So,
and this is the most relevant mechanism that you have. It works because this is a court. This is a court as opposed to CEDAW, which is a treaty body. CEDAW is important, but CEDAW is a treaty body, and formally speaking, its decisions are not obligatory. I mean, states should implement them and execute them if they were willing to be a part of that mechanism. No one made them do that. So they, by their free will, ratified the optional protocol to allow individuals to sue them before CEDAW. So, you know, you should imagine that state is willing to execute the decision as well. But it doesn't have to. On the contrary, when it comes to the court, this is the European Court of Human Rights. This is a judicial body. When it issues the judgment, this is a court judgment, and the state is obliged to execute it. This is why the European Court of Human Rights is very important. You mentioned individual applications. Yes, so individuals can go before the European Court of Human Rights. There are some admissibility criteria that your application needs to satisfy before you go. Here are the admissibility criteria. So you need to be the victim, or, for example, a close relative of yours can apply in case the person is deceased, for example. Article 2, right to life is violated. Of course, the person cannot go before the European Court of Human Rights. Then the close relative, close person will do that. So the victim status, you need to exhaust local remedies. So, for example, in terms of Serbia, you would have to go all the way to the Constitutional Court, use the constitutional complaint, and if you do not get the satisfaction that you asked for, then you can go to the European Court of Human Rights. You need to do that within 4 months period. So, from 4 months from which moment?
From the reception of their
the final decision, yeah. There needs to be compatibility with the convention, meaning you cannot go before the European Court of Human Rights and claim my right to a healthy environment has been violated. Why? Because there is no such right in the European conventions. So you can only claim the violation of those rights that are contained there, but rights, for example, gender equality. It is not explicitly guaranteed by the European Convention, but you can go claim either Article 8, right to private life, or Article 3, torture, because gender-based violence is torture or degrading inhuman treatment, etc., etc. But these are the most important admissibility criteria that I would like you to know. So why is this very important? And we will go through them more importantly and thoroughly later on. Because through its judgments, the court establishes standards. It establishes relevant duties for states parties. Because every particular right is actually, it contains duties of states, both negative ones and positive ones. Take Article 2, right to life. The convention says everyone has the right to life. Full stop. But this actually means obligations for state, both negative in the terms of not doing some acts that would deprive a person of his or her life, or positive. So positive action needed to secure the life of a person. So always think about a particular life in terms of duties of state, both positive and negative. Why is this important when it comes to women's rights? Because all provisions are guaranteed also to women. Some of the provisions are very important. Article 2, rights to life, because in cases of gender-based violence, women are sometimes victims. They are deprived of their life, or domestic violence. Article 3, torture, inhuman degrading treatment. Again, gender-based violence, human trafficking, female genital mutilation. This is a form of inhuman treatment or torture. So Article 3 is very relevant. Article 4, prohibition of slavery. I mentioned trafficking. Sometimes, human trafficking is a kind of modern slavery. It is perceived also as a kind of inhuman degrading treatment, but it is also a modern, something called modern slavery. Article 6, when it comes to the right to fair trial, women's rights can be, of course, perceived in that context as well. Article 8, right to private life. Article 14, prohibition of discrimination, and Article 1 of Protocol 12 also. And this is the end, I promise. I know that we are behind our time, but these are very, very, very important things for you to understand. Why is this relevant for Serbia? Now, Saifu, this does not regard you, but this regards and would be relevant for students from Serbia. I will remind you that Article 18 of our Constitution says that all human rights provisions, it goes without saying that women's rights provisions are human rights provisions, need to be applied and interpreted in line with Serbia's international commitments and the international standards as established by international institutions that oversee the implementation of relevant international treaties. Meaning which institutions? The practice of which institutions, international institutions, is contained in Article 18 of our Constitution.
Well, the Council of Europe is the
European Court of Human Rights. European Court of Human Rights. CEDAW. Grevio. Yeah. So those standards established in the course of the practice of those international bodies are contained in Article 18. So our bodies, national bodies of the Republic of Serbia, have a constitutional duty to interpret our national law in line with their standards. Yeah, but if you are litigating, if you are arguing, then I mean this should this is very useful. This is very useful. What is the problem? That our lawyers, usually are not that familiar with the relevance of international standards. They do not know that. That is why we are here trying to also focus on international standards, because you can use them in the course of your work. If you are a women's rights lawyer, if you are doing strategic litigation at the level of national law, national institutions, this is very useful, because if you in your complaint or whatever act that you're writing, if you refer to this and that judgment of the European Court of Human Rights where it established this or that standard, then this will mean something, or at least the judge or whoever is deciding will not be able to completely ignore it, because it is his or her constitutional duty to do that. So have this in mind throughout the course. Always think about international standards from the position of Article 18, paragraph 3 of the Constitution. So this is not just, some talk. Yeah. This is something that we can make use of. And now I go to the beginnings of my presentation. You remember, I said we will assess to which degree international instruments and mechanisms are gender sensitive, but always think about the way you can use them in order to achieve gender equality or fight against gender inequality. And as you will see throughout this course and some other courses, especially human rights course, there is much there to be used. Okay, and with this, I would like to conclude. Do we have any questions?
No, madam, I have no question.
No questions? Okay. What happened? What should I do? This one? Okay. Alexander, Una, who else do we have online? Actually, no one. Saiful said that he has no questions. Alexander, Una, was this clear?
Yes, it was clear.
Yes.
Okay. So, as I said, this is just an introduction so that you can see what different instruments and mechanisms there are. I can imagine that it might be a bit, difficult to just put each one of them in a specific category, many bodies, many different instruments, but we will constantly be going back to most of them, or if not all of them, throughout the course. What I want you to take from this class is their legal relevance, their legal nature, whether a particular instrument is obligatory or not, but also to have in mind that even though a certain instrument is a soft law instrument, you should not ignore its relevance. It can be very helpful in terms of interpreting another obligatory instrument in a gender-sensitive way. And to have in mind the relevance of different mechanisms, how you can use them, and of course, how you can use all that in the proceedings before the national bodies. When it comes to Republic of Serbia, always have in mind Article 18, paragraph 3. It should be mentioned. I'm not guaranteeing that it will work, that it will do the purpose, but it definitely can be very, very useful. Okay. I apologize for going behind the schedule. I think that we were supposed to end at 8:35 or something. But I promise that next time I won't do that. So we'll finish on time. Have a nice rest of the evening, if there are no other comments or questions. And you will be working with Professor Krstić on Saturday, and I will be again with you on Wednesday. Meanwhile, I think that Professor Dragica answered regarding your readers. So while you are still there, she took them back to her office because she wants the front page to be fixed. She's not satisfied with the front page. So if anyone wants them, I can go to her office now and give you. Yeah, so we have the permission to enter to her office and to give you. For you who are online, it goes without saying that we cannot do that. Well, that's it. Other issues are not relevant for this. It was a pleasure working with you this evening. And looking forward to seeing you on Wednesday, online or here in person. I always prefer in classroom. But if you cannot make it, then online is also fine. Goodbye, everyone.
Goodbye.
Bye.
Bye-bye.
Laco noite, madam.
Boa noite.